I would like to acknowledge the traditional owners of the land on which I work and live, the Gadigal people of the Eora Nation, and pay my respects to elders past and present. I acknowledge them as the owners of country and the holders of knowledge for this place. So today I'm going to talk about operationalising Indigenous rights in the Pacific. And similarly, I look at traditional knowledge, the protection of traditional knowledge, and cultural expressions. Slightly different, Taylor, that I also look at genetic resources and associated traditional knowledge. So fortunately, we have sort of talking on a slightly different side of things, looking at how we can use some of those biodiversity conventions as well to protect Indigenous rights. So, look, I think around the table and online, people are generally aware, but traditional knowledge is a highly valuable resource from a spiritual, a cultural, and an economic perspective. Protecting traditional knowledge from misappropriation and exploitation not only prevents the continuing dispossession of Indigenous and local communities, of which there are numerous historical and contemporary examples, but it also can operate to secure economic benefits for those Indigenous and local communities. And as Eric Irene Dace was the Special Rapporteur on the Subcommission on Prevention of Discrimination and Protection of Minorities and the chairperson of the Working Group on Indigenous Populations, has recognised Indigenous peoples cannot survive or exercise their fundamental human rights as distinct nations, societies and peoples without that ability to conserve, revive, develop and teach their wisdom that they have inherited. So, there are numerous examples of misappropriation and exploitation of traditional knowledge across the world, in Australia, in the Pacific, and it causes significant harm. It's culturally inappropriate. It leads to the destruction of cultural heritage and knowledge. And it also is a lost financial opportunity, but it also undermines other rights. So, for example, it actually undermines the Western intellectual property system where traditional knowledge is exploited and misappropriated and patented. That's an actual undermining of the right to intellectual property or intellectual property system. And there are a number of arguments for protecting Indigenous traditional knowledge, and these arguments obviously engage with human rights principles on an ideological basis. Obviously, exploiting TK is offensive and it represents that continuing dispossession of communities. And protecting TK can act as a form of corrective justice to empower Indigenous and local communities and return institutions to those communities that affirm and support Indigenous values and practice. It can support the realisation of territorial rights and self-determination of Indigenous peoples, but can also prevent further loss of traditional knowledge and culture and return economic benefits. So the protection of TK, traditional knowledge, has been the subject of debate internationally for decades. And there's been a number of treaties and declarations enacted that afford some form of protection for TK. And as Ayla has mentioned, some of these treaties, I won't spend too much time on all of them, but the continuing efforts of the World Intellectual Property Organization for decades now, there's obviously this gap, and in the absence of that sort of binding agreement at a WIPO level around protecting traditional knowledge, traditional cultural expressions and genetic resources, we're looking to other agreements to fill those gaps. So critically, where I start from for the purposes of this presentation is that UNDRIP recognises the right of Indigenous peoples to maintain, develop, control and protect their cultural heritage, traditional knowledge and cultural expressions, as well as the manifestations of their science, technologies and culture. And the declaration requires states to work with Indigenous peoples to take effective measures to recognise and protect these rights. And although the declaration is non-binding, it does represent an important recognition of the rights of Indigenous peoples and the development of an environment that is conducive in some way to greater protection of such rights. Where we do sort of move into a more binding type environment, and while we wait for the World Intellectual Property Organisation to catch up, as Dr. Buckingham, he's our expert on the IG activities at the IGC, we can look to some of our biodiversity conventions as ways of operationalising Indigenous rights, particularly in relation to protection of traditional knowledge. So the Convention on Biological Diversity provides, and its associated protocol, the Nagoya Protocol, provides some measure of protection to traditional knowledge associated with biological resources. And this includes these concepts of access and fair and equitable sharing of benefits. So the Convention on Biological Diversity is actually designed to promote the conservation and sustainable use of biological diversity and the fair and equitable sharing of benefits that arise out of that use of that biological diversity. And as part of that, there are specific provisions around recognising and protecting traditional knowledge and implementing procedures that require the approval and involvement of holders of that knowledge before using it. So Article 8J. The Nagoya Protocol then sort of takes the CBD and operationalises these access and benefit sharing provisions that were in the Convention on Biological Diversity. And the Nagoya Protocol is focused solely on the fair and equitable sharing of benefits that arise out of the utilisation of genetic resources and associated traditional knowledge. And so these obligations set out in the Nagoya Protocol are binding on member states. And there are a wide range of obligations beyond just looking at traditional knowledge. Obviously, the main focus is on genetic resources, with provisions dealing with associated traditional knowledge, but it also has a number of other obligations around compliance measures, monitoring, establishment of checkpoints, reporting requirements, conservation and sustainable use of genetic resources themselves. So it is a much broader framework, but there are specific provisions dealing with access and benefit sharing, prior informed consent, or approval and involvement of Indigenous communities before traditional knowledge is used, and that mutually agreed terms have been entered into. So consistent with these obligations, a number of countries have established legislative instruments or policies that can meet their obligations under the CBD and the Nagoya Protocol. And so implementing the Nagoya Protocol can support states in their efforts to recognise and operationalise Indigenous rights, to maintain, control, protect and develop traditional knowledge. So in the Pacific region, a number of countries have ratified the Nagoya Protocol and have established legislation, policies or other measures to meet their obligations under the Nagoya Protocol, but there have been challenges in implementation. And I was recently engaged, along with a colleague, Olivier Rukundo, to work with the Secretariat of the Regional Environment Program, Pacific Regional Environment Program, to develop regional guidelines for the effective implementation of the Nagoya Protocol in the Pacific. Now, this work wasn't solely focused on the traditional knowledge aspects of the Nagoya Protocol. It looked at the Nagoya Protocol more broadly as a whole, but obviously that includes the provisions around access and benefit sharing in relation to traditional knowledge associated with genetic resources. So this is this lovely document we have here. So the Secretariat of the Pacific Regional Environment Program, SPREP, is a regional organisation. It's established by government. There's 21 Pacific Island member countries, and SPREP has a mandate to promote cooperation in the Pacific and provide assistance to protect and improve its environment and to ensure sustainable development. And they have a number of areas of focus, but mainly climate change, island and ocean ecosystems, waste management and pollution, and environmental governance. And the project that I was working with, it's part of the Island and Oceans Ecosystem Program. There's a biodiversity unit, and this was part of their access and benefit sharing project. So a number of countries are member states, specific countries, and they've taken steps to implement the protocol, including preparing frameworks that may be implemented upon becoming a member country. The Federated States of Micronesia, Fiji, Kiribati, Marshall Islands, Palau, Samoa, Solomon Islands, Tonga and Vanuatu, Tuvalu and Vanuatu are all members, have all ratified the Nagoya Protocol. But obviously there are challenges in implementation, and particularly we're dealing with small island developing states. We identify in our guidelines sort of the main four main challenges to implementation as the lengthy procedures and requirements for ratification and processes of consultation with stakeholders. If you think about communities that may be dispersed, don't have the resources to engage in that consultation with stakeholders in developing legislation. And as Ayla mentioned, that participation is critical to developing these kinds of frameworks. There's a lack of inventory and knowledge about genetic resources in general and the potential economic value of genetic resources. There's a limited capacity to negotiate and a limited capacity to implement systems for monitoring utilisation of genetic resources. But there's been a lot of good progress, and we're seeing a lot of mechanisms being implemented that are not only consistent with Nagoya Protocol, but also the provisions around incorporating biocultural community protocols that are consistent with UNDRIP and the CBD. So relying on customary approaches to regulating access to traditional knowledge. So there are a couple of communities in Samoa recently that have documented their biocultural community protocols for engaging with knowledge held by those communities. So we identify that there are these sort of issues with implementation, and obviously different countries in the region are at different stages in implementation. But I think one of the key things that came out of it for me is that we have at an international level an expectation on implementation that doesn't hold out in reality, where we have countries that lack the resources. And we talk about this a lot, we come up with these great frameworks, and if you go into a particular country, then it's a small group of people working in the Department of Environment or relevant body that is responsible for implementing not just the Nagoya Protocol, but waste management and all sorts of other areas. And that we've got a responsibility to cooperate and assist in implementation of these obligations. But so where does this sort of fit in with economic, social and cultural rights? Well, I guess linking back to ESCR, there are a number of overlaps between sort of what we're trying to achieve under global biodiversity conventions, the World Intellectual Property Organization in terms of protecting traditional knowledge, and ESCR and where it sort of slots in with ESCR. So if you think about the right to take part in cultural life, protecting Indigenous knowledge, the benefits of scientific progress and its application, this isn't a separate. Traditional knowledge is science. Science is traditional knowledge in a lot of communities, but also if we allow the exploitation of traditional knowledge and traditional knowledge to be locked up in Western intellectual property frameworks, then we are actually restricting people's ability to enjoy the benefits of scientific progress and its applications. But we're starting to see the global biodiversity frameworks recognise the importance of human rights law, and the current development of the post-2020 global biodiversity framework that's going to be negotiated at the Conference of the Parties next month. The draft recognises international human rights law and the right to a clean, safe and sustainable environment when looking at the obligations under the CBD to the sustainable use, conservation of biodiversity and fair and equitable benefit sharing. So I think also kind of drawing on those ESCR sort of principles of cooperation and assistance are especially important in small island developing states such as those in the Pacific, and that we have a responsibility to be sensitive as to the resources that are required for compliance with any of these treaty obligations, including what may be negotiated at WIPO. And so that while there are equally tech transfer and capacity building provisions under the Nagoya Protocol, that's not resulting in sufficient support on the ground for communities or countries to implement their obligations and to protect traditional knowledge. So I guess it's a little bit of a rambling overview of where my work is at the moment, but I think the key takeaway is that we have so much on paper and it's time to, and I think Paul referenced this in a different context yesterday, sort of operationalizing it, getting on the ground and getting things done rather than just in writing is an urgent need, particularly in the Pacific. So thank you.